So I technically do have it done. I just didn't send
No,
it.
you don't technically have anything done.
Okay, well, I didn't send it out.
Young lady, you may address other people that way. You better check yourself before you're addressing me that way.
Assistant Public Defender Natalie Pate with an on behalf of Diana Johnson, who is approaching. Please state your name for the record, ma'am.
Ayana Johnson.
Thank you, Your Honor. Today is the date and time that was originally set for sentencing. I have reviewed or received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes. And they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at she does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Claire on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over, and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing.
Why?
Why, what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh, they do so much. I mean, I didn't send you the last time. I'll re-refer to defendant to Von Schwartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want
The
to.
paper,
What?
the paper with
What
all
paper?
the lists on it. What is Von Schwartz?
That's for your alcohol screening and assessment.
Is that somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced at August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant's remanded. Yes, go. Is that Dad?
Yes, Your Honor.
Get her back. Dad, hang on one second. Go ahead, take her back. Come on up to the. Can you come up to the phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through the?
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I know.
she need this job so bad.
I know. And I trust me, I did not want to. I just, Miss Clara, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is, so that he knows what she has to do.
Yes, Your
So
Honor. I do know, I heard him in the hallway, really getting after her for not doing it. So I think that he will.
Well, I don't doubt
If
that.
you stop by my office, or I'll ask them to give you the paper printed out.
Is that in this
It's
building?
right down the hallway.
Okay.
And so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.
Whose case is this? Yours?
Yes, Your Honor.
Counsel approach with Miss Clara. Recalls the case of People versus Johnson. Didn't he just tell you to take your hands out of your pocket? Oh.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Johnson. Ms. Johnson, please state your name for the record.
Ayana Johnson.
Miss Johnson, let me ask you this. Do you want to go to jail?
No.
So I'm going to tell you what. The only reason I brought you back out and didn't have you sent down is you can thank that man right there, your dad. Because if he hadn't stood up and said something to me, I would not be letting you even thinking about letting you go. There is no reason in the world you haven't gotten this done. None. Do you hear me?
Yes.
When your dad found out that you didn't do this stuff, what did he say to you?
He said they not playing with you. You should have been had it done. Stuff like that. There's no reason that you shouldn't have had it done.
And what, you don't think he was right to?
Yeah.
So why didn't you have it done?
Because I didn't check my email to have it printed out. When I got the call from her that I needed to have it done, I printed it out. I just need to send it out. I have the money order. It's literally in the car, in the envelope. I just need to mail it. So I technically do have it done. I just didn't send
No,
it.
you don't technically have anything done.
Okay, well, I didn't send it out.
The young lady, You may address other people that way. You better check yourself before you're addressing me that way.
I'm just saying, I didn't get a chance to send it out.
Because you know what? Your daddy's right about one thing. I'm not playing. Are we clear?
Yes.
Now tell me why I ought to give in to your father's wishes to let his daughter go.
Because I have to go to work. And because what I did was minor, and I'll fill it out and send it out. So you should let me go so that I can go to work so I don't lose my job.
Were you thinking about that when you didn't mail the envelope? Did you think about all the bad stuff that could happen to you?
No, not really.
If you lose your job, what are you going to do?
I'm gonna have to figure it out.
Are you in school?
I was the summer school right now,
Where?
pathways.
So you trying to get your high school education?
Yes,
How old are you?
20.
How close are you to getting your, are you going to get a GED or a diploma?
My diploma. I have to go back in August for like 2 months, and that's it.
And then what?
I have to go back for 2 months, and that's it.
And then you have your diploma? Dad, is there anything you want to say?
Do everything in my power to make sure all this gets done.
Father's prayer for his daughter. I'm going to tell you what, young lady. Miss Blair, a condition of her release once we get through this is that she gets her diploma.
I noted it already.
Thank you. Your dad says he has the $75. I want that paid today out front. You have to pay your father back.
Okay.
You hear me? Dad, you'll promise me if I let her go that if she doesn't pay you back, you'll let me know? I'm going to cancel my remand. I'm going to give you a warning. I can be just as straight up as I can be with you. You mess anything up, even that man's not going to be able to save you. You hear me? Go with her dad. Dad, thank you.
Thank you very much, Your Honor. And I do apologize. What was the adjourned sentencing date again?
The adjourned sentencing date on this matter will be August 28th.
Thank you very much, Your Honor.
Sam Bernstein for Mr. Johnson, Your Honor. Here.
Yeah,
What's going on, man?
not much. You look good in orange.
No.
All right.
Oh, yeah. So we're asking the court to please set this for a preliminary exam, Your Honor.
We
Yeah.
have all discovery shared with the exception of the 911 call that was requested earlier this week. It should be over to Mr. Bernstein by the latest on Monday. My expectation would be more likely that it gets to him tomorrow. Then the court, well, I would like to address that.
Why don't you go ahead and address phone?
So I understand in this case, bond is currently set at 10,000, cash or surety with no 10% privilege. We did request 150,000 on this case originally. I understand he has his bond currently denied out of the circuit court, and multiple holds in this case. I am actually requesting that bond be raised today, as well as his phone privileges be revoked. I am concerned because the way that I see this playing out is that he was taken into custody for this event that occurred back on May 2nd. After he was taken into custody, he was in custody for a period of time, then was released. We had, before he was released, we had stipulated to adjourn this case to May 23rd. On that day, he failed to appear in a bench warrant was issued. He was then picked up and arraigned on the bench warrant on July 9th and given the 10,000 cash surety without 10% privilege. In the time that he was in custody before he was released and since he has been picked up, he has called the victim 105 times at her personal number, as well as called the family line 110 times, where the victim answers that phone among other people a period or a number of times. I don't know what contact he had with the victim while he was out of custody, but given his failure to appear previously, as well as the extensive violations in the form of calling the victim, I would be asking for him to be increasing his phone bill to be revoked today.
Your Honor, as far as the phone calls go, Mr. Johnson states adamantly that he's not called Miss Vesey. He says that it was another woman that he's been calling, and that he has not had any contact with Miss Vesey since he's been in jail by phone, Your Honor.
I apologize. It is the victim's phone number because the victim has called our office and provided that phone number that he has called 105 times as her point of contact to our office.
That's my mom. That's not her number. I call my other girlfriend. That's my mom.
He says he's calling his other girlfriend, Your Honor. I'm sure Miss Barroso will get me the phone calls. I'll listen to him ASAP. If there's something different, then I'll know within like a day or two. I know what Miss Vesey sounds like on the phone, so I'll be able to tell whether it's her or not.
Your Honor, I'll say something, Your Honor.
Usually doesn't work well, but go ahead.
I know. Yeah, the number that I've been calling, I got two girlfriends. One is Mrs. Vesey and the other is Jaleesa. I called Jaleesa off of my phone number. It's an 858 number. It's registered to my name. It's in my name. Miss Vesey's phone number, I do not call at all. And when I was coming out here, I seen Miss Vesey in the back. Miss Vesey can attest to you. I ain't called her or I haven't called her. I know the contact order, so I know I ain't supposed to have no contact with Mrs. Vesey at all. So I called my other girlfriend, which is Jaleesa. And then once you hear the phone, once you get the phone records, the 100 and whatever times, I'm not too for sure how many times I called her, but once you get the phone records and you hear the phone records, you will clearly hear that it's not Mrs. Vesey, it's Miss Jaleesa that I am talking to on the phone. Now, if you can hear the records as well, you hear me on that phone call, those same phone calls, telling Jaleesa that I cannot have no contact with Mrs. Vesey, and for her, I can't have no third party contact as well with Mrs. Vesey. So once y'all able to get the contact or the phone records or whatever to my attorney in this court, y'all can listen to them and make the determination. But I don't call Mrs. Vesey, and Mrs. Vesey is in the.
All right. Well, let me ask you this then, since you decided to volunteer this. As between your two girlfriends, would there be any reason they would share a number?
No, there's no reason that they would share. No.
So why would the prosecutor indicate that the number that the victim in this case gives them to contact her is the same number that you're calling for the jail?
Now that I don't know. I don't know why she would indicate that or what even would give the indications that I'm talking to Mrs. Vesey, but Mrs. Vesey was right there.
Okay, do these two women know each other?
Yeah, they know each other for sure. I mean, like I said, we was in a three-way relationship, so like they know each other for sure.
Okay.
And Mrs. Vesey right there, if you would like to call her up here.
No.
Or she can attest. I can't talk to her. I got both of them pregnant at the same. You know what I'm saying? So like,
to be fair to James, Your Honor, what we're not hearing is anything about the substance of those calls, whether he's talking about court or proceedings or anything directly related to Miss
The
VC.
same time?
Yeah.
Oh, okay. All right.
Yeah,
Checking.
yeah.
Go ahead. No, my bad.
Yeah.
I'm sorry, Mr. Bernstein. I didn't mean to interrupt.
I was just saying, Judge, what we're not hearing is the substance of those calls that relate specifically to Miss VC. Anything that would indicate that it is Miss VC herself. We're talking about the number, but as far as like what's on those calls, I mean, what we're not hearing does kind of support what James is saying, that he wasn't calling Miss VC, Your Honor.
Okay, I don't, so there's no way without me seeing, I mean, you haven't seen them, Mr. Bernstein, that we're gonna know. But my posture on those cases is that if the people are representing to me that the number is the same, I don't know what's going on. Doesn't matter to me. All I know is that the number is the same. I'm not sure what those conversations are. Mr. Bernstein will listen to it, but this time I'm going to revoke your phone privileges. And certainly, Mr. Bernstein, after you hear the calls, if the court needs to reconsider that, I will entertain that and potentially restore his phone privileges. Okay.
That means is when you revoke my phone privilege, is it to that number or is it to all my family?
I'm sorry.
Because I call my grandmother, my other kids, mothers, and all that. So is it revoking that number?
I get you. I'm just saying that what I'm hearing right now is that you violated a condition of your bond. You're telling me you haven't. I've got this phone number. Your counsel hasn't heard it. So what I'm saying is I am, as an initial position, going to revoke your phone privileges. He'll get the phone messages. He'll be able to get to you. They can get to me. I'm not saying I might not restore them, but at this point, this is what I'm going to do.
Okay.
Okay.
All right.
I'll get on it fast.
Yeah, because I need to talk.
So his phone privileges at this time are revoked. With reference to the bond amount, when is the other hearing on?
It shouldn't.
So, and that's the case that bond's been denied.
Yes.
So, okay.
He's not going anywhere anyway.
Well,
So
I know. I get that. That was going to be my point. I just wanted to check the dates. And so I'm just going to continue his bond as it's currently sat until we can get to the bottom of it, because he's going to have a preliminary examination before that other case comes up. I'll set preliminary examination in person, July 30th, 2024, 9 a.m. That's before me. Thank you.
Thank you, Your Honor.
Same time. Court calls case people, state of Michigan versus Bobby. Mr. Johnson, keep going. Just keep moving. Quit talking. Court calls case people, state of Michigan versus Bobby Beach.
Via my computer, but it looks like we're able to do it now. Thank you for taking the time out, sir. I certainly appreciate it.
Oh, not a problem. We just finished the docket, so yeah, I'm good.
Yeah, I imagine you stay busy out there. Before we go further, is it okay if we send a photog out to your courtroom tomorrow? Take a picture so we can get that out of the way.
Tomorrow
or any day. I mean, whatever day works for you.
Well, tomorrow is our PCC day, and it is very busy in here. But
we'd be in. I'm sorry to interrupt you, sir. We'd be in and out. It's just a matter of getting a shot of you on the bench so we can anchor. It's a layout issue on our end, you know.
Got it. Yeah, tomorrow will work. Just if you could coordinate that with Miss Weiling, I'd appreciate it.
Will do, sir. Thank you. Now, as I said in the
go ahead.
Oh, sorry. Yeah, as I said in the email, I'm kind of taking a look at this issue. I mean, and you know, that thing got a lot of yucks, I guess, in terms of the driver thing, and I guess there were some issues that came out that weren't quite true. We can get into that. But I mean, this is more than that. I mean, there's a lot of issues that pop up because you're streaming live now. Am I correct on that?
There are issues that arise, but I don't think, people have their view of the different issues, but I don't see them as being huge issues. But, I guess it would be, how one views the world and how the world communicates that people just have their different views of what should happen.
Yeah.
So.
Now, this particular case, that kind of did a little bit of a wind up after it blew up. Correct? What was how did that come out?
Can I just say, let me, and we might have to stop because I am very hesitant to discuss Mr. Harris's case, and my reasons for it are not because I don't have certainly things to say, but that case is still pending before
Gotcha.
me.
Oh, okay.
And doesn't conclude until, may conclude on the 7th of August. And so I have had numerous requests, as you can imagine, for people to talk to me about that case, and I just have not talked about that case directly. And I don't think it would be fair to Mr. Harris. I don't think it would be fair to the people of Pittsfield, and I think my judicial canons also prevent me from doing so.
No, of course not. Okay, I got you. In terms of you say the problems. So I know you guys are busy out there too, and I've heard that for a lot of these, it just saves so much time. I mean, could you talk about what's the realities now that people are streaming? What that has done for your docket?
Well, there are two parts to this really, and a lot of people don't understand it, but one is the technology involved in how people access the courtroom. And then there's the streaming portion of it where it's then broadcast to the world. And they're really two separate parts. The saving of time really comes in how people access the courtroom and how, come in. To me, the pandemic caused a lot of problems. But out of those problems and those challenges, if we're smart, we can take pieces of that to help make our system more efficient. And I think with the Zoom aspect of it, the access to the courtroom, we've done some smart things. And I say it this way, normally, particularly for district courts, we're dealing with people, they're out living their lives, they've got their jobs, they've got this, they picked up a case, whatever it is. And for them to take a day off of work to come down and sit in a courtroom for 2-3 hours for what may be a 5-minute hearing and might be an adjournment of a proceeding and miss work, interrupt their lives, it makes no sense. So in that respect, that is a great thing, I think, that has come out of it. The streaming aspect of it gets a little bit more complicated, but I think the streaming aspect of it really opens up our courts so that people can see exactly what we do. I have just not been one. I've been on the bench 25 years almost, and I don't want to hide what I do. I don't want to hide what goes on in the courtroom. I think people should know. I think our whole system is really predicated upon the notion that, it's open to the public and the public is entitled to see what we do. There are those who, I guess, have the view that what may happen in a courtroom embarrasses somebody. Well, except when there's statutory justification to close a courtroom, our courtrooms are open.
Yeah.
And so people ought to be able to see what happens in the courtroom. They ought to be able to see those cases. None of it is meant to put somebody in a circumstance where they're embarrassed or that. But the reality is anybody could walk in, they could see exactly what happens if they're going to sit there. And so maybe it's the ease of it streaming that is the problem. I am, just philosophically speaking, I would prefer that people know what's happening in our courts. because I think in a lot of ways, the hardworking judges of the state get the short end by people not seeing what we do. People make up what we do.
Yeah.
They think that what we do is we just want to send people to jail. We want to do this and that. And, I'm not everywhere, so I don't know what goes on everywhere. But when I'm able to see my colleagues around the state and see certainly my colleagues in the county, that is not what we are sitting here trying to do. And people can get, I think, when they can see it, at least a portion of it, and from a certain point of view, they can begin to see really what happens. Why somebody's maybe going to jail, what really is the story with that person. So
yeah. Now you've had a couple of these cases blow up. My wife, full disclosure, watches all those Dan Abrams courtroom TV, and I've seen on there a couple times because I covered the case with the transgender woman who wanted her testicles back, and then she came before you in a thing, and I'm not getting into that, I promise you, where you said sir, and then you apologized and you kind of chided her. Look, I know you remember that, but there was some that went on TV independent of that I've seen you, and I'm like, I remember that, Joe, and this was before that. Do you remember what those ones were?
That came on before. I don't watch a lot of social media, so when they come out, and people bring them out for various reasons. The woman, the transgender woman, that was a circumstance where actually we had been getting along just fine. There wasn't really an issue. I required her to do something, and I don't think she wanted to do it.
Yeah.
And and it was one of those things where I said the wrong thing. I apologized. At that point, it's then up to her to either accept my apology or not.
And I'm not even getting into that in my story. I promise you, that's a sidetrack. Okay. Not even worth going into. It's not. That's not what I'm about. But I think